Hi, my name is Charles Hadad, and this is my colleague Mallory Sikora. We're both attorneys at the Lynch Law Group, and we practice in our Estates and Trusts group. And we are here with another video to talk to you about an important topic: foundational estate planning documents.
Yeah, certainly with COVID lately, this has become a much hotter topic than any other given time. A lot of our clients are asking, what are these key foundational documents that I have to have? What should I have in place, healthcare-wise, financially, and planning for the future?
Absolutely. Really important topic. First, estate planning documents are essentially documents that fulfill your wishes while you're alive, such as a financial power of attorney and or a healthcare power of attorney. Those documents allow you to appoint a loved one, family member, friend that you trust that can make those decisions for you if you're unable to communicate at any time while you're alive. Very, very important foundational documents. Another document that helps you while you're alive that's part of the foundation is what's called a living will. And that is a set of instructions of the types of care or treatment that you prefer, or what you do not prefer be given to you if you're unable to communicate, and if you're ever diagnosed to be suffering from what's called an end-stage condition. Those three foundational documents help you while you're alive. The other very important foundational document that is triggered when you pass away that everybody should have is what's called a last will and testament. And that governs your goals when you pass away, on how you want your estate to be governed, who's managing it, such as an executor, and who's going to receive the transfer of those assets, and that they are called a beneficiary.
And then what happens if you don't have these documents in place?
Very, very good question. Thank you for raising that, Mallory, because it's really important that everybody knows that if you don't have estate planning documents in order, that's technically like you're making your own plan, but who gets to direct it is Pennsylvania law. And it might not always be what you prefer. Pennsylvania has a set of statutes called the intestate statute. It's actually in Title 20 of the Pennsylvania Pardons Code. And it directs, based on the relationships of beneficiaries or next of kin that you are survived by, on how your estate is distributed. And more often than not, if you compare one of our clients' goals to the intestate statutes, they're not the same. So that's what triggered if you do not have a will. I do not recommend that you do not have a will as a result of it.
And then how about those financial powers of attorney and healthcare powers of attorney? What happens if I don't have those in place?
So with a financial power of attorney and a healthcare power of attorney, if you do not have those, essentially you're leaning on the court system to appoint someone on your behalf to fill that void if you're unable to communicate and make those decisions. That actually is a hearing petition process, what's called guardianship. And it can be very cumbersome, it can be very lengthy and costly when you compare it to the efficient cost of implementing a power of attorney, both healthcare or financial. I always tell our clients that it doesn't matter if you have a penny to your name, it doesn't matter your age, if you're an adult, or if you have millions of dollars from an asset standpoint. Everybody should have those foundational documents, and I would recommend that you check out our website at lynchlaw-group.com, and if you have any questions related to these topics, please contact either myself or Attorney Sikora, and we'd be more than happy to schedule an appointment and answer any questions that you have.